Justice Thomas, anything further? Justice Alito?
On the question of the meaning of coercion, I can think of a spectrum. On one end of the spectrum, a government official says, look, suppress this speech, and if you don't do it, I have legal weapons I can use against you, and I'm going to punish you using those. That's very clear coercion. At the other end, the government official who has no authority to do anything for any practical purposes to the entity that the government official is speaking to says, you should do this, it would be a good thing to do, you'd be a good citizen if you did it. And in between, there are a lot of different gradations, particularly when the official who's making this request has that power, and you have to assume that the person or the entity to whom or to which the request is being made knows that, just as I am sure that these insurance companies were well aware of the power of Ms. Vullo. So how do you define when it goes too far along that line?
So I do think that the power of the official over those to whom she is speaking is a relevant factor in the assessment. But the assessment is, at the end of the day, would a reasonable person in this situation feel that the government is coercing it, that it is implying some sort of threat of action against it, of adverse action against it. So the mere fact that someone exercises regulatory power over you, I don't think is sufficient. But when combined with what you have here, explicit requests to punish a group because of its advocacy, and the invocation of the very tools she has to make life miserable for them, you're not managing reputational risk. We might fine you, or you've got these technical insurance infractions. We might go after your partners and require them to never provide you affinity insurance ever again. This is on the first end of the spectrum that you identified, Justice Alito. So I agree there are hard cases in the middle, and that's true with any standard that at the end of the day looks at coercion. In the context of confessions, coerced confessions, there are some hard lines to draw. This one is not.
Okay. The Solicitor General urges us not to consider the enforcement actions against Lloyd's, Lockton, and Chubbs and the consent decrees, and it argues that the district court held that those actions are entitled to absolute prosecutorial immunity, and petitioner has not challenged that holding here. Do you want to comment on that?
Yes, thank you. Respondent never asserted absolute immunity with respect to the Bantam books, the First Amendment claims in this case. Absolute immunity was only asserted with respect to a separate selective enforcement claim. They chose, with respect to the First Amendment claims, to only assert qualified immunity. That's number one. So it was not asserted below. It was not asserted in the Court of Appeals. It was not raised in the bio. It's not appropriate for this court to decide at this stage.
Thank you.